Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Carly Odell presenting for us. If you are unfamiliar with the format of this event, first, Carly is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Carly will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Carly to get us started.
Thank you so much, Marissa. Welcome everybody to today's Listen and Learn. We are going over simple divorce. And of course, everything today is provided by Legal Aid of North Carolina. My name is Carly Odell. I am a staff attorney with the Legal Aid of North Carolina Durham's office, and I am happy to be here presenting today. Let's talk first a little bit about Legal Aid, who we are. We are a statewide nonprofit law firm that provide free legal services in civil matters to low-income people in order to ensure equal access to justice. It is very important to us, as you see here, to remove barriers and uphold opportunity for everyone. Different areas of law that Legal Aid does involves housing, employment, education, domestic violence, disaster relief, consumer issues, Medicare and Medicaid, healthcare signups, government benefits, veterans legal issues, human trafficking, and immigration issues. If any of these issues are something that you are facing, you can always contact Legal Aid's helpline to see if there are any services that Legal Aid could provide, which is available right here at that phone number, or you can also apply online at our website, which is legalaidnc.org. As Marissa stated earlier, Legal Aid is not your attorney. We do not represent you, and we will not be representing you for any future cases you may decide to file after watching this presentation. This presentation is simply a public forum to inform you on how to file a simple divorce and going over the different steps that you will take to file on your own. Please make sure that any questions you put in the chat are not case specific, as we will not be able to answer those questions. Again, this presentation is designed to help you do this yourself, and no attorney participating today will represent you in court. Today, we're going to be reviewing a few different things. First, we're going to make sure that this is the right filing for you. Some people may not be eligible for a simple divorce because there are things such as property or spousal support and alimony at issue as well. And today we are going to be talking only about simple divorce. If you do decide that filing is right for you, we'll talk about gathering information and what you will need to gather in order to file. We'll talk about filling out the forms that will be needed to file for a divorce. We'll be talking about the methods for filing the forms, and then we'll be talking about what happens when you actually get a divorce judgment and get it signed. So, is a simple divorce right for you? You'll want to ask yourself, have you or your spouse lived in the state of North Carolina for at least 6 months on the date that you would file for your divorce? This is required. So if you have not lived here for at least 6 months, you're going to have to wait until that 6-month period comes along. The next question you'll want to ask is whether you and your spouse have been living separate and apart for an entire year prior to the date of filing. Living separate and apart means that you two are no longer living in the same household. Even if you are living in the same household in separate rooms, that is not enough to effectuate a separation for the purposes of filing for a divorce. You have to have been living in separate homes for 1 year before you file. And you also have to have been living with the intent to be separate and apart. There can be no periods where you got back together. It is an entire full year of separation. No try again periods, living in separate homes. You'll also want to think about whether or not you do want to file other claims involving property division, which would be called equitable distribution, or anything regarding spousal support, which could be post-separation support or alimony. This stuff involves your money, and after an entry of a divorce judgment, after a divorce judgment is entered, you will not be able to file any claims for property division or spousal support. These claims must already be pending for your divorce to be entered if you would like them. So keep that in mind before you file a divorce. If you would like to divide any property, money, seeking support, we recommend strongly that you speak to an attorney before filing anything at all. Do not file a divorce. Do not file for any of the spousal support or property division. Speak with an attorney so they can give you the best information on how you should move forward. A simple divorce will not impact your custody rights, however, if you do share children with your spouse. So you are free to file for custody at any point, and if you do file for a divorce, it will not affect your ability to file for custody in the future. Similarly, a simple divorce would not have any impact on any child support claims, which are separate from custody claims. All right, so if we're at the point where we've decided, I think I want to file for a simple divorce, there's going to be some information that you will need to gather in order to file properly. There's going to be information about you that you need to gather and information about your spouse that you'll need to gather. Obviously, you'll need both of your full legal names. So that would include your first, your middle name if you have one, and your last name. You're going to want to have your address, and you're going to want to have your spouse's current address. That means the place that they have been living separate and apart from you for the last year. If you have a marriage license, it is very helpful to have this, as it will have some information that is important, such as the date of your marriage. If you do share any children, you'll want to have their full names and their birth dates if they are children that you share with your spouse. You'll also want to know the location of the clerk of court in the county where you plan to file, because that is where you will need to physically take your documents if you are filing in person. Although some people will have the option to e-file, which is completely online. The other information about your spouse is whether or not they are in the military. Even if they're active or inactive, or if they've never served, this is information that you will want to know, as there is a specific form about being a service member that you'll need to fill out for filing a divorce. Other things you may need is a printer or a way to take files to be printed out somewhere. A lot of times you're going to be getting a packet or a package from whatever you're going to be filing, and these are going to need to be printed off and handed to the clerk of court for a signature in person. Some things are going to need to be signed in front of a notary, so make sure that you keep an eye out for those forms. If it does need to be signed before a notary, that means you have to sign it in person in front of them. So wait to sign that form, and you'll want to know where that person would be, where a notary would be located to get that done. And you'll also want to know the location of a post office close to the clerk of court, as at times there will be a requirement for you to mail things out. Okay, so North Carolina Guide and File is the pretty much number one way that you would file or start the filing for a simple divorce. The North Carolina Guide and File is an online 1-hour interview survey that gathers all of your information and fills out the forms for you. The interview is going to be shorter if you already have all of your information gathered, which is what we went over before. And what you can do is either print the forms when you're done and file it with the clerk of court, or as I mentioned before, some people will have the option to e-file, and that means they can file their documents online. So the North Carolina Guide and File, like I said, is free to use. It is an interview online that will automatically fill out the information for you on the forms that you need. And it will allow you to stop and start as you need. You can create an account so that you can come back to your specific interview that is going to be going over everything that you would need to file. It is very specific and it is very straightforward on what kind of information that it is asking for. And at the end, like I said, when you have everything filled out, you can either print all the forms that you would need. It'll prepare all of them for you. You just need to print them out and bring them to the clerk of court in the county where you're going to file. Or if you are in an e-filing county, you can e-file them as well. Guide and File is pretty easy to find online. You can simply Google Guide and File and find the link to get to the interviews. But this link that we have right here should help you get there as well. And I'll wait just a moment to let people take a picture or a screenshot if needed. Okay. So right now we're going to be talking about the fictional case of Blue Blood versus Blue Blood. I'm not going to go through the actual website on here, but I'm going to talk about what this is going to look like. And I'm going to be using a fake case just for the purposes of explaining what this online interview through Guide and File is going to look like. So once you get onto the website for Guide and File, the option for absolute divorce is going to be the first one that you see when it lists all the different types of interviews. And it says absolute divorce. That is going to be the one that you will want to select for the purposes of your simple divorce, which is what we're going over today. So when you get into that, you are allowed to start your interview. And what it will remind you is that you need to answer all of the questions because it will fill out the forms for you. It will remind you that this form and these forms, this filing will not involve any claims for spousal support, alimony, property division, things like that. It'll tell you that you need to read things carefully because you do need to make sure you are reading things carefully. And it'll tell you to be truthful because it is very important that you are truthful when you are answering the interview questions. At one point, it will tell you about the lawyer referral service because if you do determine that you believe you need to speak with an attorney, you can have a consultation with a private attorney, which you can find one through the lawyer referral service, and they will share that information if it is applicable to you. There will be different check boxes to say, I agree to this, I know what I'm doing. And it will also give you the option to make an account, like I said, so you can come back in if you don't want to do it all at once, can sign out, come back another time and finish. It's going to go over a list of everything that you will need. So it'll remind you, hey, get this information before we start the actual interview. And that's going to be the most helpful. Today, like I said, we're talking about this Blue Blood versus Blue Blood case. We're talking about Mr. Dexter Blue Blood and Miss Caroline Blue Blood, who are going to be getting a divorce. And Mr. Dexter Blue Blood is going to be the one that's filing. Before it gets into this interview, once again, it's going to ask you, is this right for you? It'll go over the requirements needed, such as living here for at least 6 months and being separated for at least 1 year. It's going to remind you again that it does not help you with certain things such as custody, spousal support, alimony, property division, and it will say once more, talk to a lawyer if these are things that you want to file. Once you actually get into the interview, the first thing that it is going to ask you is your information. So for Mr. Dexter Blueblood, he lives at 105 Devil Drive in Durham, North Carolina. He's going to put his address down. It's going to ask for his date of birth and some other information, and he's going to put that down and make sure he answers every applicable question that he can on that page. Now, what I will say about the person who is filing in their address, if you meet certain requirements, you may be able to have your address listed as confidential so that you do not have to put it on certain court documents. But like I said, there are certain requirements for that, and this interview will discuss those if that is applicable to you. Moving on, Mr. Dexter Blueblood is going to be putting in the information for Caroline Blueblood, which is the person that he is filing the divorce against. He's going to want to put her current address, which is 321 Tar Heel Trail in Chapel Hill, and he's going to be putting her date of birth as well. It'll ask for your date of marriage. It'll ask for your date of separation. It's going to ask if the person you are filing against is in the military, because as I said before, there's a special form that you have to fill out. And if someone is active duty military, there are different rights and a different process involved. So it is very important to fill out this form. It's going to give you the option to review a website that you will be able to look up someone's information if necessary. Otherwise, you can select that you didn't use that website. It'll ask you to write in a sentence or two about how you know this person is or is not in the military. And since you had a marriage relationship, that is the basis for why you would know whether or not this person is in the military. So for example, Mr. Dexter Blueblood was married to Miss Caroline Blueblood for 15 years. So he is going to write, I was married to Caroline Blueblood for 15 years, and I know she is not an active duty military. If you have children, you are going to put their information as well. The Bluebloods do have one child, Miss Tammy Blueblood, and they're going to want to put her full name and her date of birth as well. Once you get through putting all of the information that it requests, it's going to ask you again to be sure, are you going to make any claims about spousal support? Are you going to make any claims about property division? Because again, those are going to be wiped away, the right to file those once an entry of your divorce judgment occurs. So it's going to be sure that these are not things that you want to file. And if they are things that you want to file, you need to wait to file your divorce and you should speak to a private attorney. It's going to ask you if you want to change your name, because you can do so and make that filing as part of this as well. But there is an extra $10 fee on top of the $225 fee for filing the divorce on its own. That is essentially all of the questions that you will get for the absolute divorce interview. Once you finish that part of the interview, it's going to have another interview for you to go through. And this is for indigency. If you want to apply for indigency, meaning that you would have any fees waived, you would fill out this form. And if you have received any benefits such as food stamps or TANF, you would indicate this. If you are receiving any free legal services, such as from Legal Aid, you would indicate this as well. Otherwise, filling out that form, the clerk, it is in their discretion to determine whether or not they find you as indigent, and they can find that the fees are waived. So this interview is going to ask you, do you want to fill out this form and request to be determined as indigent or not, or can you afford the filing fee? If so, you don't have to fill out that form. Once you get through that part of it, it's going to ask you some more questions about whether or not you're e-filing, which again means you're filing this case online, or it will give you the option to print off all the forms, which you would then take to the clerk of court in the county where you want to file to physically file them. There is an alternative to doing the guide and file, which is downloading all of the forms. These forms can be found on the North Carolina Courts website at this link below. I will pause so you can take any screenshots or pictures if you want to write this link down, but the next page will also cover which forms you would need. Okay, so the forms that you're going to be needing, the forms that you would be printing off or e-filing if you do the guide and file are the complaint form. This actually doesn't have its own form number, and this is something that you can find on our legal aid website, but it will give you this if you do the guide and file on your own. A civil summons form, which is AOC-CB 100. This is a picture of the website and where you're going to search that form number. The domestic civil action cover sheet, which is AOC-CV-750. This form is pretty self-explanatory. It just has some check boxes about which kind of complaint you are filing. AOC-G-250 is that Service Member Civil Relief Act affidavit. When I was talking about whether or not someone is in the military, this is that form that is going to be filled out. And then the optional form of AOC-G-106, the petition to proceed as indigent, which is if you are asking the court to waive the fees for divorce, which again, it is $225 to file for a divorce, $10 for name change if that is something that you want to do. And then there is another form for affidavit of indigency, which goes along with the petition to proceed as an indigent. Make sure you check with your county, with the clerk of court in your county about any extra forms that may be required. Every county is different in how they handle divorce and how they handle filings, how they handle the hearings, how they handle the judgments. So make sure you're asking the clerk and they'll be able to give you the best information. All right, at this point, if we've gone through the guide and file or you filled out those forms at home, you are ready to actually file. So if you are filing in person, you're going to want to make sure that you have each of these forms and at least 3 copies of the first ones, and then 2 copies of the petition to proceed as an indigent if that is something that you are going to be filing as well. Something to note is that some counties will require 2 copies of the civil summons to be on yellow paper. Again, you'll want to check with the clerk of court in your county that you're filing so they can give you the best information on how to do this and how to file. Make sure you do not sign anything early. I mentioned before that some forms are going to need to be notarized and they have to be signed before a notary in person. So don't sign anything early that may need to be notarized. Remember to make sure that you have the necessary number of any copies and all of the documents, and all of those documents, if they need to be signed in front of the notary, sign them in front of the notary and not anytime sooner. Once everything has been properly signed, is properly printed off, you have everything you need, the correct color of paper if it's required to be yellow. Go to the clerk of court in your county, hand in your paperwork. That is when the clerk will file stamp the paperwork, give you a file number, and give your extra copies back to you. The next step is going to be serving the defendant, which is giving the defendant a copy of the paperwork. There are different ways that you can serve a defendant. The best way, the easiest way, and the most proper way to serve a defendant is by sheriff, but you also do have the option to serve by certified mail, which takes some extra requirements. Or if all of those other methods fail, you can serve through publication, and I'll talk a little bit more about that. It is important that when a defendant gets served, that they are being served with 1 complaint and 1 summons for it to be proper service. And there also has to be proof in the court file that the defendant was served. So if you're serving through the sheriff is going to have a form for return of service that indicates clearly that the defendant did receive this paperwork. If that you are serving through certified mail, there is going to be the green slip that comes with it, and there's going to be some extra forms that you're going to have to fill out and make part of the court file to prove the defendant was served. With publication, again, that's a little bit different, and you have to also have tried the other ways first, and those have to have failed. By sheriff, sometimes this process can be done at the clerk's office. So again, speak with the clerk of court in the county where you're going to file about the best way to get stuff served, because they may be able to help facilitate this. What you will do typically, though, is go to the sheriff's department and ask for assistance with civil process. You will give them 1 complaint and 2 civil summons. Sometimes, again, those civil summons need to be yellow. Make sure to check with the clerk of court. There is going to be a $30 service fee unless you applied to be considered indigent and your filing fees are waived. Otherwise, it's $30 on top of what you already paid to file for the divorce and the name change if applicable. The deputy who serves the defendant will note the date and time on the back of the summons and send it back to the clerk. That's why you want 2 copies of the summons. One of the complaint and one of the summons is going to go to the defendant. The other one will be signed by the sheriff to indicate service and sent back to the clerk. And that is going to be the proof that you need that the defendant was served. If you want to check up on whether or not the defendant has been served, you can contact the sheriff's department for updates. You will need to know the date the defendant was served. This is an important part and requirement of the case moving forward. If you're going to be serving a defendant through certified mail, the process is going to look a little different. Here, you're going to need 1 complaint and 1 civil summons, put them in an envelope, and take them to the post office. You will fill out the green card, the green slip with the defendant's name and address for a certified mail, and pay the postal fee. If the defendant properly receives it, that green slip is going to come back to you with the defendant's signature and the date that they received that specific envelope with the paperwork. You'll want to keep this green slip because it is the record of the date the defendant was officially served, as indicated on the green slip. You will further have to file an affidavit of return of service by certified mail. Once you do receive that green slip back, this is what that form is. You're going to want to fill it out properly, indicating when the defendant was served and where they were served. And you're going to want to actually attach that green slip to this affidavit. Then you will take this affidavit to the clerk's office to file it along with the civil summons. And this will also indicate when the defendant was served and how. And this is the proof that is required for showing the defendant has been served with this paperwork. The next thing that you'll need is the acceptance of service. So you will actually need your spouse to sign this form, acceptance of service, in order to indicate that they were served. So you'll have to also have the complaint and civil summons to your spouse, give that to them, have them sign this form that acknowledges that they were served, and you can give that to the clerk of court as well. Now, publication, it's the last resort. Like I said, you have to try the other ways of service before you can try this one. You have to use reasonable means to find the defendant, which could include attempting service by the sheriff or certified mail at the last known address, which we just went over. You might have to do internet searches to double check on where this person may be located and may be served at. You will have to contact their family or friends, try to find out information on where they are, looking into DMV information, maybe even hiring a private investigator to find out where is this person so I can properly serve them by sheriff or certified mail. before you would go this route, you should always contact the clerk of court to see what specific requirements there are, if any, before you use publication. And publication specifically is publishing that there is a court filing of this sort in the newspaper where it is likely that the defendant would be able to read it. But again, last resort, you have to use reasonable means to serve the defendant otherwise, and there may be specific requirements, so you should double check with the clerk of court in the county where you're going to file. All right, so let's say we've gotten through this point, we've filed, we've got the defendant served, and now we're at the point where we just need to wait for an entry of judgment, which is the judge ordering a divorce. There are different ways to have a divorce entered. There can be a judgment of absolute divorce before a clerk. This is not necessarily common. I think I have heard that in certain counties, there's a number of clerks and only one clerk would be willing to do this. Again, I've said it so many times, I know, but it is very important to check with the clerks in that county so you can get the 101 on what you're supposed to be doing and how this whole process, including the entry of the divorce order, works. There is also the uncontested testimonial divorce before the judge. However, like I said, the procedure of the entry will be different from county to county. Contact the clerk of court, see if there are specific rules or customs, things that you need to do where you filed your divorce action. Most likely it'll be before the judge, but it could go before a clerk. When we're talking about the testimonial divorce hearing, you do have to wait at least 30 days from the date the defendant was served before you can schedule this hearing. So let's say he was served the beginning, or they were served at the beginning of this month, got to wait 30 days and then you can set the case. However, you'll want to contact the clerk's office to determine which date the hearing can be set. You will also have to file certain documents when you are setting this date, which typically will include a notice of hearing, which is another form that says the court date and what people are to appear for, as well as a certificate of service, which is proof that someone has been served with this. Again, we're emphasizing that you need to check with the local clerk of court to figure out if there's a specific process or a specific form that is required in that county. You are going to need 4 copies of any document that you are filing for a hearing before a judge. So make sure you keep that in mind and have the proper number of things that you will need. And then you're going to have to mail a copy of each document to the defendant via US mail in order to serve them. When we're talking about a notice of hearing, some counties will only conduct divorce hearings on certain days of the month. So you need to make sure that you're providing the defendant with enough advance notice prior to any hearing. There is a requirement that there has to be 5 business days of notice before the hearing. So no weekends, no court holidays, but 5 business days between when this person is getting notice of the hearing and that actual hearing date. So because you are mailing this, you want to make sure that it is likely that that person, you want to make sure that you're mailing it within 5 days, 5 business days, no weekends, no holidays before that actual hearing. Because if you do not provide sufficient notice, this could result in the judge not hearing your divorce and continuing the case as there wasn't proper notice given, which is required. If you are in doubt about the dates, just add in a few extra days to make sure that you're in the clear and nothing is going to be continued for being improper. So if we're having a testimonial divorce, we talked about that you want to have 4 copies of certain documents, but what are those documents that you're going to want to have? You're going to want to have a judgment of absolute divorce, and you're going to want to have a certificate of absolute divorce or annulment, as well as a stamped envelope with the defendant's address on it. 4 copies of the judgment of absolute of divorce. This is the thing that the judge is going to be signing that says you guys are divorced. You're going to need multiple copies of it. 1 copy of the certificate of absolute divorce or annulment. And then these forms will need to be filled out either on your computer and printed to court somehow, some way. I believe they may be part of the guide and file, but if they are not, these are forms that you will be able to find online, and Legal Aid does have some sample forms available as well. So the actual hearing itself, like we said, you'll need to have the 4 copies of the completed, filled out judgment of absolute divorce and 1 copy of the certificate of absolute divorce. Oh, and here it says right in here, they are in your guide and file package. So if you do the guide and file online, this will be given to you already. Just want to make sure that you have the correct number that you will need. When you go to a hearing, you want to dress business casual. Courts are considered more of a professional environment, so just keep that in mind. No hats. If you are wearing something, a certain kind of shirt that might look more professional tucked in, wear something that is a little bit longer than usual, that sort of thing. Just keep that in mind when you are going before a judge. Certain counties may have more specific rules. I do know that some counties do require that men tuck in their shirts, so keep that in mind. You should arrive about 15 minutes early before your hearing is scheduled. You want to make sure that you give enough time for parking. Sometimes there's a big rush for parking and you might have to park farther away. Make sure you consider that. You also will have to get through security to get through the court, to get into the courthouse, so make sure you have enough time to get through security properly. Once you get there, you can go into the courtroom, sit on the bench, and wait for your case to be called. When your case is called, you can approach the judge's bench. What the courtroom officials should be able to direct you specifically where you should go. Sometimes there are tables for you to sit at. If you are going up to the stand to testify, it is called the witness stand, and they should be able to direct you on where to go and where to stand. If at any point the judge is directly speaking to you and you are not testifying, you should be standing when speaking to the judge, if you are able to. When you are testifying or speaking to the judge, just make sure to speak slowly and clearly so that the judge can understand you and everyone can clearly hear what you are saying. You can use your judgment of absolute divorce as a guide for your testimony. It's going to go through different pieces that you can use to assist with the answers that you are giving when you are speaking to the judge about your divorce. This is what that looks like. And so, like I said, you can use it to kind of guide you by saying, I am a resident of Orange County, the defendant is a resident of Durham County, and going through each thing. Here, I see they did put in some blue blood information and it's different than what I said, but we can pretend it looks the same. So this should print as part of your guide and file packet, as I mentioned before. Make sure you have 4 copies of this with you. And if the judge is deciding to grant your divorce, they may ask you for this specifically so that they can sign it right there, then and there in court. At the end, you want to make sure that you do mail a copy of this judgment on the date indicated on the certificate of service via the US mail. So this is that certificate of absolute divorce or annulment, which again should be printed along or given along with the guide and file forms if that's the way you do it. And the clerk will be able to fill out the remainder of the form that is not already filled out. After a hearing, the judge is going to then determine if your divorce will be granted after listening to your testimony and looking over the pleadings, which is all the documents that you have filed as part of the case. If the defendant isn't there, which they don't have to be, you have to send it to them. Make sure you complete the certificate of service for the judgment of absolute divorce. And after that, you're going to want to mail a copy of that judgment to the defendant via the US mail. Keep a copy of the judgment for yourself in a safe location with your other important papers. If your judgment does include a provision for name change, you may want to obtain at least 2 certified copies of this judgment, which can assist you with changing your name through Social Security and through the DMV. All right, and that is the entirety of our presentation today. If you do need help or other services beyond this clinic, you can contact legal aid. You can apply online at that website right there. And now I think we are going to turn it over to questions.
Perfect. And so we do have a couple questions on Facebook and on Zoom, just to remind those, because I did see some raised hands. You cannot unmute in this form. If you have a question, you need to type it either in the Q&A box if you're on Zoom, or the comment section if you're on Facebook. First question, someone's asking, if you can't afford to move, like to live that separate and apart, is there some sort of leeway that can be done in terms of getting a divorce because you financially can't afford to be living in separate places from the spouse?
Unfortunately, no. The requirement for a 1-year separation is for everyone, and there are no exceptions.
Gotcha. I've seen a couple questions about what I'm assuming is service. One question is asking, what do they do if they can't find the other spouse? And then another one is asking, actually, no, we'll start with that one because the other one's a little different. So what can someone do if they can't find their spouse to
Right.
file a
So
divorce?
you'll want to definitely speak with the clerk of court in that county just to see what the specific requirements are for what you have to do before you can do the publication method. So if you really have no way to find your spouse and you have exhausted all means possible, publication is a way for them to be served, but there may be specific requirements. So you'll just want to make sure that you check with the clerk of court to see that what it is and make sure you do that. Otherwise, they'll be able to inform you about the process of publication for purposes of service.
Gotcha. If the person filing and their spouse live in different counties, does it matter which county the divorce is filed in?
It should not matter which county. It should just be, I don't think it matters what county at all, but I do believe it should be either county that either one of you live in. And if there are going to be other claims for like alimony or property settlement, it is best to do it in the county if there's like a house, for example, where that house is located.
Perfect. This question is asking if there's like a separate monetary support agreement, can that be filed? Can someone have that and still do a simple divorce, or would they still need to probably go more complex
Yeah,
avenue than a simple divorce?
yes, if there is some kind of separation agreement, it will actually ask you about it if you do the guide and file option. It's going to ask if you have a specific agreement that is required to be incorporated into a divorce order. So that is something that would be possible to be filed along with your divorce filing.
Perfect. Do you know about ways to serve someone who might be in a different state and how the requirements there?
From my understanding, they can still be served by sheriff. They would just need to be served by the sheriff of the county where they're living. So, some way, somehow, you will want to have contact with the sheriff of that county and give them the forms that they will need to serve the defendant, and then they can send back that civil summons, which indicates that there has been service, back to your clerk of court. And once that is received, that is the proof of service. And then same thing with the certified mail. If you don't want to do the sheriff's office route, you can serve them via certified mail. You just have to make sure you have that green slip and those forms that indicate that you're doing it through the mail, certified mail.
Um, for putting the shared children on the forms, do you only do that if the shared children are minors, or do you do that if the shared children are adults as well?
That is a good question. I do believe it is only for minor children, but I am not 100% on that one. And I would just recommend double checking with the clerk of court, but I do believe it is just minor children.
Perfect. Uh, I think this is more of a clarifying question. Someone's asking they can file for child support after filing for, they don't have to file for child support when they're filing for their simple divorce, and they wouldn't lose out on that option for child support. Is that correct?
Correct. Yes. Filing for having an entry of absolute divorce does not affect your right to file for child support or custody.
Some more questions about service, and if you can't answer some of these, totally understandable. Um, do you know if certified mail can go to a PO box?
From my understanding, there is a signature requirement for certified mail, so I don't believe that would be adequate. But I might contact the post office to get more information on how that would work.
And then similarly, can FedEx be used to serve for service?
I do
Or
believe
is it
that
just US mail?
I
I
do
have no
believe
idea.
that FedEx is allowed so long as there is just something that will be returned to you that indicates that the defendant, that person was served and what date they were served. That's going to be required for your proof.
Okay. And then I think I'd already posted it in the chat, but posting it now. Um, Someone asked about getting Legal Aid North Carolina's divorce packet that we put together. I have not posted that in the chat. Um, does getting a divorce in North Carolina, are you able to get divorced in North Carolina if you got married in a different state?
Yes, you just have to be living here for at least 6 months and be living separate and apart for a year.
Okay. And is there any way to avoid service? Say the defendant and plaintiff are both, it's more of an amicable situation. Can they just show up and sign papers, or does there actually have to be some sort of service?
There does need to be service, and that is, I think that would be the best way to handle that would be um through handing them that in person. There was that one form where they can acknowledge that they were served. If it's going to be amicable, they just need to sign that form, which indicates that they were served a copy of the paperwork.
Perfect. And as I am not seeing other questions, gonna give it like 2 seconds here to see if something else comes in really quickly. Okay, perfect. As I am not seeing any other questions, I'm going to go ahead and say thank you to all of you for joining us, with a special thank you um, to the person who has their hand raised. Hold on. You cannot unmute in this form. If you have a question, you need to type it in to the Q&A box. So I'll give just a few moments to see if that person types in. Are separation forms available on the NC Court's website? Or just like any standard forms about separation agreements, not necessarily divorce?
So in order to be separated, there are no requirements aside from you just have the intent to be separated and you are living separate and apart. But for separation agreements, there may be some example forms online. I don't believe that the courts provide anything because separation agreements are not required by any means. So I think that there should be maybe some different law firms have example ones online, but there's not any official separation forms because the only requirement, as I said, is just being separate and apart and having the intent to be separated.
Perfect. Did not see anything else get typed in, so I am going to say thank you to all of you for joining us, with a very special thank you to Carly for presenting and for answering all of those questions. If you would like to review anything that was discussed today, we have posted a recording of today's event to our Facebook page. It will be immediately available for about the next 30 days. If you want to watch it after that time, you will need to go to Legal Aid of North Carolina's YouTube page, as might not be available on Facebook anymore. If you would like to register for one of our other listeners on things such as child custody, tenant rights, wills, and power of attorneys, you can do so on our website at legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their day.
Thank you, Marissa.